Hello everyone, welcome to my channel. Let's start with the new topic, Public Trust Doctrine. Public Trust Doctrine under Environmental Law. Let us start with the introduction. What is Public Trust Doctrine? Public Trust Doctrine is a legal principle that says certain natural resources like air, water, forest, sea are important to all of us. Government must protect them for the benefit for the public. State as a trustee is under a legal duty to protect these resources for a public good and cannot transfer them for the private ownership or for the commercial exploitation. If we talk about the origin of the public trust doctrine has originated in Roman law, where it says that the things like air, sea, running waters are common to all mankind. Further, this doctrine has been developed in English common law, and many countries have adopted this doctrine, including the India. The doctrine became the part of environmental jurisprudence through the landmark judgment by the Supreme Court. The importance of a public trust doctrine based on a 3-point. First is to prevent the arbitration allocation of our natural resources. Second, to impose the fiduciary duty upon the state to protect the resources. Third, to protect the common resources of mankind for the future generation. However, in our Constitution, Article 48A, which was added through 42nd Amendment in a Part 4 of the DPSP, which talks about the protection and improvement of the environment, where it is the duty of the state to protect the forest and wildlife. One of the important landmark judgments regarding the public trust doctrine is Mcmethav.Kamalnath, 1997. In this case, a private company has allowed to construct a hotel on the bank of the river in Himachal Pradesh, where company changed the natural course of a river to protect the hotel from the flood which caused and damaged the river ecosystem. The PIL was filed by the Mcmethav before the Supreme Court, and Supreme Court has delivered the judgment and held that the government had violated its duty as a trustee of natural resources by allowing the private party to tamper with the river. The Supreme Court also ruled that the state is a trustee of all the natural resources which are nature meant for the public use and enjoyment. State is under a legal duty to protect them. Court also applied this doctrine and said that environment cannot be privatized, and the several judgments such as Fimoto Central of for Environment Law in this both case, first case where the court held that beach and coastal area are the public trust property and they must keep open for the public access. In a Central for the Environment Law and Union of India, in this case also court applied this doctrine, and court held that to protect the forest area and declare the wildlife and the forest are the national assets that must be protected by the government as per Article 48A. Let's end with the conclusions. The public trust doctrine is a powerful legal tool that prevent the government from selling or destroying the natural resources for the short-term commercial gain. It reminds us as environment belongs to everyone, not just for today people but for future generation too. You can follow my blogs, study on law hills, and the notes is also given in the description. You can download from there, and I have my Instagram ID where I post several notes. You can join there also. You can see the several posts on the LinkedIn also. Thank you everyone.